Hello, everybody, and good morning. So we have a bunch of new filings in the Bryan Kohberger case. Some of this is pretty interesting, you guys. We're going to wait for people to get in here, and then we are going to start. Hey, CSI, good morning. Haven't even had my morning coffee yet, you guys. I'm just drinking it now, but I got this new information that's just come out. It was just posted this morning, so you guys are going to be the first to see it. Hello, Miranda. Please smash that like button on your way in. Get us out there in the algorithm so we can get going on this. It's free to do. Also, I do have it on subscriber only mode. It's free to subscribe. That just helps keep some of the trolls out. So once you're subscribed, you can start chatting after a minute. So please hit that subscribe button and hit that notification bell. Good morning, Sherry. Karen Baird, good morning. President Marie, good morning. You're very welcome. Wendy, good morning. Elizabeth, good morning. Good to see you guys all here, bright-eyed and bushy-tailed. Good morning. Shannon's Copper. Good morning, everybody. Great to see you guys all in here. Okay, so like I said, there's a bunch of new filings in the case. Brian is also going to be asking for a reduction in bail. There's a new non-dismissal order. What else we got here? A new custody order for the sheriff. We've got the court minutes. And we've also got the notice that they want to have a bail reduction. Let me just see here. So while you guys are getting in here, good morning, Fruit Fly, Tanya Hodges. Let me just get this set up in the order that we're going to go in. We've also got a notice of appearance and the bail reduction request. We've also got an order regarding the Zoom, and we've got his days for the preliminary. So those are the new things that have been filed this morning. So we're going to go over those. Good morning, Susan. Good morning, Nayam. Good to see you guys all here. So I'm going to ask Bonnie Baker, Great Lear. Good morning, everybody. Everybody coming in. Please smash that like. We've got 24 likes and 57 people in here. Please smash that like. Let's get it out there in the algorithm so we can get going on this. You guys can see all the new filings. Oh, I really hope he doesn't either. So I'm going to also ask, please no sharing other channels. Any information that you get somewhere else, let's not be sharing that here. I keep everything verified here so you guys know when you do come here that you are going to get verified information. I agree, Gen C. I agree. Thank you guys for smashing that like so we can get going in here. 31 likes, 60 viewers. It's all free, you guys. It's free to smash that like too. I do a lot of work and it takes a lot to be able to just jump on and get this up and ready for you guys. A like is showing me that you guys like this kind of stuff, and it's also helping me get my video out in the algorithm. Thank you, you guys. Good morning, Nana. Okay, let me just finish getting these set up in order here, and then we will get going on them. Also, just to let you guys know, once the video ends, it does go private for about 15 minutes for it to upload to YouTube, and then it will be available for everyone again. So if you're just joining in halfway through, whatever, and the video goes private, just know that it will be back public within usually they take about up to 15 minutes, but it is back public again for you guys. Hello, Miranda. Sensible Crime. Thank you, my dear. Thank you so much for that. Hitting that like button is free, you guys. Come on. Okay, so let's get started on this, you guys. Hello, Deborah. We're going to go over all that. Okay, so let me just get to the part where they're going to be speaking about that. Let's get through this. They're not very long. Each one is 1 or 2 pages, very short, but there's information in here that I know a lot of people, including myself, are going to be a little upset about some of it, but we'll get to that, okay? So let me just get my screen shared here for you guys. Oh, we'll make it bigger for you. Okay, you guys, so here's the first one. This is the amended non-dismission order. Apparently, they have not been happy about some ex-lawyers and this person and that person giving out information, so they have amended the order. We're going to go through it quickly. It's only 2 pages, so we'll get through this one quickly. Then we got the custody order. We've got the court minutes. We got another order. Then we've got where he's going to ask for a reduction in bail and stuff like that. And then about the Zoom in his preliminary hearing. Okay. So let's get started with this, you guys. There is a balance between protecting the right. Let me just get over here. Protecting the right to a fair trial for all parties involved and the right to free expression as afforded under both the United States and the Idaho Constitution. To preserve the right to a fair trial, some curtailment of the dissemination of information in this case is necessary and authorized under the law. Therefore, based on the stipulation of the parties and with good cause. Hereby ordered, the attorneys for any interested party in this case, including the prosecuting attorney, defense attorney, and any attorney representing a witness, victim, or victim's family, as well as the parties to the above entitled action, including but not limited to investigators, law enforcement personnel, and agents for the prosecuting attorney or defense attorney, are prohibited from making extrajudicial statements, written or oral, concerning this case, except without additional comment, a quotation from, or reference to the official public record of the case. This order specifically prohibits any statement which a reasonable person would expect to be disseminated by means of public communication that relates to the following. You're very welcome, Allie. We'll get to that, Whitney. Evidence regarding the occurrences or transactions involved in the case, the character, credibility, reputation, or criminal record of a party, victim, or witness, or the identity of a witness, or the expected testimony of a party, victim, or witness. So this is interesting because there's a lot of people that I think that are going to be called as witnesses that are speaking on the case. The performance of results of any examination or test, or the refusal or failure of a person to submit to an examination or test. Any opinion as to the merits of the case or the claims or defense of a party. Any information a lawyer knows or reasonably should know is likely to be inadmissible as evidence in a trial, and that would, if disclosed, create substantial risk of prejudicing an impartial trial. Any information reasonably likely to interfere with a fair trial in this case afforded under the United States and Idaho Constitution, such as the existence of or contents of any confession, admission, or statement given by the defendant. It's guilt or by the defendant, the possibility of a plea of guilt or any opinion as to the defendant's guilt or innocence. It's further ordered that no individual covered by this order shall avoid its prescriptions by actions directly or indirectly, but deliberately, that result in violating this order. They're not playing here, you guys. It is further ordered that this order and all provisions herein shall remain in full effect throughout the entirety of this case unless otherwise ordered by this court. So this was dated yesterday, 2 days ago, sorry. It was just put into the file, so, and then it's just the ending of that. Okay, so next we've got a custody status order. Right now, it is stating that he is being held with no bail. The above-named defendant appeared in the Magistrates Division of the District Court this date, and the Sheriff of Latah, don't come at me for not pronouncing it right, please. I'm trying my best. County is hereby notified of the following custody status. The defendant shall comply with the following terms and conditions upon release from custody. So these are all the terms in it. If he is released, which they have crossed out because he's got no bail right now, these would have been the terms that he would have had to follow, like must appear, not violate any laws, not consume or possess any alcohol, or enter into any bars or liquor stores, not to consume, possess any controlled substances, unless lawfully prescribed, stay in contact with the attorney, sign a waiver of extradition before being released from custody, not to possess any firearms or weapons, and not to have no contact with the alleged victims. So that was the next court date is June, I think it's 20th, isn't it? Let me just check. Or is it the 26th? Hello, Steffi. June 26th at 9 a.m. is his next hearing. Now, that may be moved up, you guys. We'll see what happens in these next documents here, because I have a funny feeling that this date may be moved up. So this was ordered on the 12th of January. Okay, so court minutes. Now, this was filed on January 13th, but it didn't hit the record until yesterday, like late yesterday, early this morning. So here's the date, January 12th, location courtroom 1, reporter, whatever. State of Idaho, William Wofford Thompson Jr. and Ashley Jennings are for the state, and Ann Taylor is for Brian Kohberger. So the hearing started at 8:07. The court noted the presence of counsel and stated the defendant is present in custody. Ms. Taylor stated that the defendant is prepared to waive his right to a speedy preliminary hearing. Now, I want to go over this. Everybody is saying he waived his right to a speedy trial. He did not waive his right to a speedy trial. He waived his right to a speedy preliminary hearing. From the time that his charges are read to him, they have 14 days to do either a grand jury indictment or a preliminary hearing. They're going by preliminary hearing. That's the only thing that he waived his right to, his preliminary hearing. By law, they have to have it within 14 days. That's what he waived his right to a speedy preliminary hearing. He wants his preliminary hearing set out till June. Okay? So all these, and I know there's a lot of other people like myself that previously worked in the legal field or law enforcement that are saying that he waived his right to a speedy trial. He did not waive his right to a speedy trial. I will 1,000,000% guarantee you that. There's one channel that I really like. They're retired cops from, I think it's New York. I really like their channel. When I get the chance to watch them, I do. But they've got it wrong here. He did not waive his right to a speedy trial. So, and as stated, the defendant is requested a preliminary hearing at the end of June. Ms. Taylor requested at least 4 or 5 days for the preliminary hearing. Mr. Thompson stated that for the state's calendar, July would work better, but would make it work for June. The court stated that the court's calendar would be better for the end of June. Court advised the defendant of the rights he is waiving upon waiving his right to have a speedy preliminary hearing. Defendant understood. In response to inquiry from the court, the defendant stated that he did not need any additional time to speak with Ms. Taylor regarding his waiver. The defendant waived his right to have a speedy preliminary hearing. That has nothing to do with his trial, you guys. So, I mean, sometimes, we get it wrong, but I just want to make that clear. He did not waive his right to a speedy trial. Ms. Taylor agreed with the waiver. Court found the defendant's waiver of speedy preliminary hearing was knowingly, intelligently, and voluntarily given in open court with the assistance of counsel. Court accepted the defendant's waiver. Court set, and don't forget, his right to a speedy trial only starts once he's arraigned. He's not been arraigned yet, okay? So this in no way affects the speedy trial. The clock starts ticking for speedy trial once you are arraigned. Court set this case for a preliminary hearing on June 26, 2023 at 9 a.m. and will reserve the entire week. Court stated that the hearings will begin at 9 a.m. each day. Sorry, I had a cough there, you guys. Court remanded the defendant into custody of the county sheriff without bail. I'm not even going to attempt to say this because I know I always say it wrong and I get torn up in the comments. So I'm just going to leave it out. You guys can see it right there. And I'm French too. So it's like sometimes the way I pronounce certain letters and whatnot, it's not intentionally, I'm not doing it intentionally. But between English and French, that's enough for me. So I do my best. Hearing end time, 8:11. So he was only in there like 4 minutes. Pretty much, Whitney. It also gives his defense team time to go over maybe evidence that they took, as we all know that they were given the right to go back into that scene and collect their own evidence and that. So, and again, for all yous that are just coming in at the end of this will go private for a little bit. I think it's for about like no more than 15 minutes for it to upload from my streaming software up to YouTube. So please know that it's not going to stay private. It just does that so it can upload. Okay, so that's the end of that one. So let's this one now. Okay, so this one is one of the ones that I'm not too impressed with. Doesn't look like we're going to be able to watch this. So order regarding notice of hearing and the Zoom information. The court is mindful that limited courtroom capacity and potential travel restrictions may interfere with the victims and the defendant's family's ability to observe the court proceedings in this case. Therefore, in the event they are unable or prefer not to attend the proceeding in person, the court finds it necessary to make the proceedings available via Zoom for the victims and the defendant's immediate family members under the following restrictions. The victims and the defendant's immediate family members may observe the court proceedings in person or via Zoom. They have blocked out the meeting ID and the passcode, which means we are not going to be able to see it. The Zoom information above shall not be disseminated to anyone other than the victims and the defendant's immediate family members. Any recording or live streaming of the proceeding is prohibited. So, like I did yesterday with the Chad Daybell and Lori Vallow case, I'm going to have to give it to you guys without showing the Zoom. We're not going to be able to stream it, but you're still going to get the up-to-date information. I'm going to bring it to you just like I did yesterday with the new stuff that came out in the Lori Vallow and Chad Daybell. If you haven't seen that, the judge made immediate orders yesterday regarding their little powwow they wanted to have and all that. Go check that out. I did that video yesterday. You can find them all my latest videos, you guys, over the last 3, 4, maybe 5 months. You can find them all under the live tab at the top of my YouTube page. The video tab is more of the older stuff that I've done over the last couple of years. But all the new stuff is all done under the live tab. Okay, so notice of appearance. Okay, here we go. So, this is Brian's lawyer that filed this. Again, it says filed on the 12th, but we just got it. It was either late last night or early this morning. This was put into the record. So you guys are going to be the first ones to be able to see this. I don't think anybody else has seen that it's in the record yet. Okay, so notice of appearance, request for timely preliminary hearing, motion for bail reduction, and notice of hearing. So I haven't read through any of this yet, you guys. I got it, and I got this all set up for you guys right away to switch as quick as I could, so you guys would be the first to see it. But this request for timely preliminary hearing, and this is from his lawyer, as you can see right up here, the public defender. That's Ann Taylor is his public defender. She's the one that filed this. She's the one that requested it to be put out till June. So I don't know why she would put it like this, request for timely preliminary hearing, because a timely preliminary hearing would have been the 14 days that he was entitled to from the time his charges were read to him. Usually within 14 days, they have to have a preliminary hearing. And she set it out till June. So it kind of confuses me as to why she's put it, the request for timely preliminary hearing. She's also got a motion here for a bail reduction and notice of hearing. Comes now Ann Taylor, public defender, and pursuant to court appointment, hereby appears for and on behalf of Brian C. Kohberger in the above named defendant in the above entitled matter, and requests that a preliminary hearing be scheduled in accordance with the time limits set forth in Idaho Criminal Rule 5.1. So Idaho Criminal Rule 5.1 says you got to have him for a hearing, a preliminary hearing within 14 days. So this is weird because she's the one that asked for it to be set out till June. And now she's requesting a preliminary hearing be scheduled in accordance with the time limits set forth in Idaho Criminal Rule 5.1. Criminal Rule 5.1 is states that they must have a preliminary hearing within 14 days. I get that, CSI. CSI says timely, not speedy. Yeah, so with her saying this in the first, when he was in court before, he requested by and through his attorney that he wanted his preliminary hearing put off till June. But now she is making a motion requesting for a timely preliminary hearing. But then down here, the defendant in the above entitled matter and requests that a preliminary hearing be scheduled in accordance with the time limits set forth in Idaho Criminal Rule 5.1. Okay, how about this? Hang on a second, you guys. Let's go there. Idaho Criminal Rule 5.1. Let's see what it says. So Rule 5.1 deals with the preliminary hearing. And it says, if the magistrate determines that a public offense has not been committed or that there is not probable or sufficient cause to believe that the defendant committed the offense, the magistrate must dismiss the complaint. Okay, but let's see what the timeline says on here. Yeah, 14 days. So the preliminary hearing, unless indicted by a grand jury, a defendant charged in a complaint with a felony is entitled to a preliminary hearing. If the defendant waives the preliminary hearing, the magistrate, I'm reading the Rule 5.1 exactly as it says here. Okay, so if the defendant waives the preliminary hearing, which he didn't do, the magistrate must immediately file a written order in the district court requiring the defendant to answer, which means bring him in front for an arraignment. If the defendant does not waive the preliminary hearing, the magistrate must schedule a preliminary hearing with a reasonable time, but in any event, not later than 14 days following the defendant's initial appearance. So, if the defendant is in custody and no later than 21 days after the initial appearance, if the defendant is not in custody. So he's in custody. So now she wants them to follow the rule. The rule says they have to have him in a preliminary hearing within 14 days because he's in custody. If he wasn't in custody, it could be put out to 21 days. So by her requesting a preliminary hearing be scheduled in accordance with the time limits set forth in Idaho Criminal Rule 5.1. Council hereby moves for a reduction of the bail set in this matter on the grounds that it is excessive, and further, notice is hereby given that council will present argument in support of the motion to reduce bond at the time of the preliminary hearing status conference and or preliminary hearing scheduled in this matter if defendant is in custody. Looks like she copied and pasted some of this, but anyway, council intends to present evidence and or argument in support of all applicable factors outlined in the Idaho Criminal Rule 46. Okay, well, let's see what that one is. Idaho Criminal Rule 46. And don't forget, you guys, Idaho has some of its own rules on top of the federal rules, right? Okay, so Rule 46 states, a defendant may be admitted to bail or released on the defendant's own recognizance by the court in which the defendant was convicted pending an appeal on consideration of the factors set forth in subsection C of this rule, unless it appears that the appeal is frivolous. Well, that has to do with appeal. I think she got the wrong rule here, because Criminal Rule 46 deals with appeals. So I don't know. Council intends to present evidence and or argument in support of all applicable factors outlined in Idaho Criminal Rule 46. Well, Criminal Rule 46 deals with cases that are in the appeal stage. So she's messing up here. I don't know what she's meaning by this. It doesn't make sense to me. Council further notifies council and the court that such requests will be heard at the preliminary hearing status conference unless the case proceeds to a hearing. What? It's not up to her to order that. That's up to the judge. Anyway, this is weird, you guys. This is really weird. If the case proceeds to hearing, bond shall be addressed at the time of the preliminary hearing. She's making basically orders here that are not hers to make. This is up to the judge to say when it will be heard. But I guess she feels that she can tell the judge when this is going to be heard. I just find this really odd. She's messed up a couple times here already. Seems like even before I seen that, and this is the first time I'm seeing it, you guys, seemed like some of this was copy and pasted because it didn't flow right. And then this here, Rule 46, deals with appeals, so it doesn't apply here. And then her basically saying when these things are going to be heard. I don't know. Council hereby moves the court for an order shortening time for bond to be addressed if timing is insufficient. Deborah, you can go back and watch it after from the beginning. It will be private for a bit once the live ends, but it will be back within 15-20 minutes public. So council hereby moves the court for an order shortening time for bond to be addressed if timing is insufficient. I don't get this, you guys. I really don't. I don't get what she's trying to accomplish here. The defendant hereby demands a speedy jury trial. See, there you go. The defendant hereby demands a speedy jury trial, as is guaranteed to him by the 5th, 6th, 14 amendments. So there you go. What I just said when we were discussing what other channels are saying and blah, 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 and everybody coming at me saying, oh, well, this is a lawyer and these are cops. They know more than you. I'm sure they do know more than me in their selected fields. But when I'm reading court documents, I did this for over 30 years, you guys. And people are saying he waived his right to a speedy trial. No, he didn't. No, he didn't. He waived his right to a speedy preliminary hearing. Has nothing to do with the trial. The speedy trial clock does not start ticking until you are arraigned. The arraignment has not even happened yet. But this is just flipping me out here, because now she's demanding he demands a speedy trial. Well, you've put the preliminary hearing out until June, which really cuts into, even if he was arraigned tomorrow, I don't know, you guys, it just doesn't make sense. Everything that she said at the previous hearing, she's not saying that here. She said she wanted the preliminary hearing put out till June. By the looks of this, she cites Rule 46, but Rule 46 only deals with appeals. She's talking about the preliminary hearing status conference, that she wants that addressed at the preliminary. I don't know. This is just a mess. To me, you guys, this paperwork is just a mess. But from what I am seeing here is now she's changing her mind, because now she is saying the defendant hereby demands a right to a speedy trial. Up here, she has now said, where was that? Okay, so up here, right at the beginning, she's saying, and requests that a preliminary hearing be scheduled in accordance with the time limit set forth in Idaho Criminal Rule 5.1, which means 14 days from his first appearance. Time's ticking. But so now she's asking, she wants the preliminary hearing within the 14 days, but she's already set a preliminary hearing date for June. Doesn't make any sense. And she's saying she wants a reduction for bail. Well, there's no bail. So a reduction of no bail from what it is now, it's set at no bail. A reduction of that could be, okay, $10 million. You know what I mean? Because bail is set at no bail. How do you reduce no bail? Well, set it at 10 million then. Right? Because to me, if I was the judge, okay, well, we set it at no bail. You want a reduction in that. Okay, 10 million. That's what I would say. Like, because she's not making any sense with what she's doing here. This is just a mess from Ann Taylor. Sorry, it's just my opinion. Very confused here. You demanded that it be put, the preliminary hearing be put to June. Now you're demanding that you have your preliminary hearing in accordance with the time limit set in Idaho Criminal Rule 5.1. I looked it up, even though I knew Criminal Rule 5.1 says 14 days from first appearance. He already had his first appearance. We all seen it. But now she's demanding, she wants it scheduled within the 14 days. Then this bail thing and just the way that she's written this out, whoever typed this out for her, I don't know, maybe it's not her that, dictated it this way, but this is how it's written. It just seems very generic, and somebody just copied and pasted some stuff in here and maybe changed a couple words. And then she says she intends to present evidence under Rule 46. Under Rule 46, that has nothing to do with this. It's Rule 46 applies to appeals. Then she's telling the court when the court is going to hear these instead of the judge. The judge usually sets dates for these hearings, not counsel. It's just a mess, you guys. And now she also states that the defendant hereby demands a speedy jury trial. So, which means that they have 6 months from the time he's arraigned to get him to trial. Well, this is probably why he wants this over and done with. So now it's like, forget the June thing. We're going to go back to this. Let's change this. Let's change. I don't know, but she's a mess. As guaranteed to him. Yes, he's guaranteed to a speedy trial. And by you putting his preliminary hearing out to June, he only is arraigned after the preliminary or the indictment, grand jury indictment. So he won't be arraigned until after the preliminary that is scheduled to last a week. So you're into July now. And then you got 6 months from the time he's arraigned to get him in front of, to get his trial going. So it's like, I feel like she's very, very, very confused here. So you got January, February, March, April, May, June would be speedy trial if he's arraigned today. So is that why, I don't know, you got a criminology student as a defendant and you got a lawyer who's a public defender, and neither one of them at this point reading this document are making any sense, or to me, it doesn't seem like they know what the hell they're doing. Because even if he was arraigned today, his speedy trial would be he would be entitled to a trial by June. But you've put off your preliminary hearing till June. It's like, I don't know. Notice is further given that the defendant herewith asserts all rights according to him or her. See, this is what I mean. This is why I think there's a lot of this that has been copy and pasted. Are you not sure if your client is a him or a her? I'm very sticky when it comes to stuff like this, you guys, because I did this for over 30 years. And it's just stuff like this that I catch that maybe others don't. But to say, notice is further given that the defendant herewith asserts all rights accorded him or her. Accorded, it should have been, you should have stopped, right? This should not have been in there. Under the 5th, 6th, and 14th Amendments to the Constitution of the United States, and under Article 113 of the Constitution of the State of Idaho, and all probabilistic measures imposed upon the state pursuant to said constitutional provisions, including but not necessarily limited to the right to remain silent and the right to counsel. What? I'm just shaking my damn head, you guys. No agent of the state or person acting in such capacity is to question the defendant in regard to any act, whether charged or uncharged. Like, this is a hot mess. This, I hope this is not how things are going to go in this case, because this is a hot mess, in my opinion. It's a hot mess. I'm still like, I'm shaking my head. Request that preliminary hearing be scheduled in accordance with the time limit set forth in Idaho Criminal Rule 5.1. You want it within 14 days. But you said it in June, and now you want a speedy trial. And okay, so let me just check some of these. I don't have a mod in here, you guys, so let me just go through some of this and see the comments before we go on to the next one. They did deny him bail, Deborah. You guys are very welcome for covering this. So he brought himself more time. Well, Whitney says, so he bought himself more time. Sorry, you guys, I'm on studio, so I can't pop this up on screen right now. I'd have to scoot back over to StreamYard, but okay. So Whitney says, so he bought himself more time. Yeah, he bought himself more time for his preliminary hearing by scheduling that out into June. But now by what she's stating here, right here, requests that a preliminary hearing be scheduled in accordance with the time limit set forth in Idaho Criminal Rule 5.1 that says within 14 days of his first appearance. So now she's taken that back by what she has written right here. A lot of this seems like or whoever did this, maybe she's got an intern or something, but it looks like a lot of this is just copy and paste, and we'll put that in there because it sounds good, but it doesn't make sense. But anyway, this doesn't make sense because she's already set it out to June, but now she's requesting the preliminary hearing to be held within 14 days of his first appearance. I think it's been that already. And she's also asking counsel hereby moves for a reduction of the bail set. There's been no bail set. It's been no bond. So how can you reduce that? You can't. Like, this is what I mean. I think a lot of this is just copy and pasting and throw it in there, see what sticks. I say that a lot. But it just none of this makes any sense the way she's doing it. And then presenting evidence or argument in support of all applicable factors under Rule 46. Rule 46 only applies to appeals. So why she's even using that, I don't know. Well, I think she needs a new assistant or something because this is just a whole mess. Counsel hereby moves for the court in order shortening time for bond. Now she's asking for a bond hearing, but up here she was asking for a reduction. Like it's a mess, you guys. It's a mess. This for people like myself who's been in the business for a long, long time. I'm retired now, but doing stuff like this for years, over 30 years, it just irritates me. And then like even stuff like this, like it looks amateur. It's amateur. It's amateur mistakes. And it's amateur mistakes by some of the way I went over it already, what she's done up here. It's just amateur. So I guess that was a pretty winded answer to your question, Whitney. Shivani, no, it's a mess. As we went through the document, I've scrolled back a lot in comments here, you guys. So I think you might have another opinion now, Shivani, on that. Once we've read through this document, it doesn't make any sense. Gene P says, I think BK would be a flight risk if nothing else. Yeah, he would. That's why he's got no bond. Heidi Porter, hello from Louisville. Hello. Appreciate the style and class in which you present the information. Wow, thank you. I hope you have a fantastic day too, Heidi. Regardless of how Country Girl Life says maybe she wants the preliminary hearing quicker because of the unsealing of the search warrants for his residence, or maybe she's in over his head and BK is telling her how to proceed. He can tell her how to proceed, but it's up to her to put it in these documents. Now, if she has somebody like an intern or something helping her with this, I think she needs to get a new one because this is a mess. Sensible Crime says you can be brilliant and make a mistake. Yeah, but there's too many mistakes in this. There, Shivani. Sorry, but Ann Taylor sounds confused, so I don't see how she could be confused. Exactly. So I said I thought she was, pretty good when it first, the little that we did see her in court. But now reading through some of her paperwork, her first motion that she's filed, it's a mess. Paddington says she is super smart, but he calls all the shots. Yes, he calls all the shots, but he doesn't write up this paperwork. And this isn't showing me she's super smart by this paperwork. he can tell her to do certain things. She has to put that properly into her paperwork. There's proper ways of dealing with the court. And as a lawyer, you should know how to present things to the court properly and not a mess like this. Kim says she knows what she's doing. She's getting him out on bail. No, she's not. She ain't getting him out on bail, Kim. Sorry, but nope. Nope. Paddington says he's panicking. Oops, I just missed that. But it's not him writing this paperwork, you guys. That's what I'm trying to get across to you. No matter what he says to her, she has to follow his what he wants. Yes, but it's up to her to put it properly into paperwork. And when you start citing rules that don't even apply to this case, a rule that applies to only appeals, then you got a problem. He's not going to get out on bail, you guys. I have no idea how long she's been an attorney. Paddington says she apparently is a brilliant defender. At almost 60, she must have a lot of experience. Well, it's not showing in her paperwork. Shivani says the severity of the 5 charges against Kohberger will prevent any lowering of the bail bond. There's not going to be no lowering at all. Zero lowering. He's going to be held without bond. Unless he can prove that he didn't do this or there's reasonable doubt to him doing this, that will come out at the preliminary hearing. If the judge feels like, this could be a really tipsy case, she could allow him out on bail. But if she feels that absolutely the prosecution has proved beyond a reasonable, and don't get me wrong, the preliminary hearing does not have to prove beyond a reasonable doubt. The preliminary hearing has to show that there is more than likely enough evidence to show that he did this. So if the judge finds that there's more than enough cause to think that he did this, she sets it over to trial. She sends him to trial where that's going to be decided. But the no bond hold will stick. The only time that judge will lower the bond is if, I feel like there's a lot, but there could be something there where he could, his defense could come up with something that it's not him. Then she would give him bond. Ghost said, oops, damn it, where'd that go? The lady speaking in this video, was she an attorney? I worked in the legal field for over 30 years. I started off as a legal secretary. I got into family law, which I quickly got out of because it was just too much for me with what I seen, and quickly got into criminal law where I worked under many lawyers. I got my paralegal. I also did a lot of private investigations. And since when I retired from that, I went in and opened my own business for paralegal and skip tracing, process serving. And now I am fully retired as of last year. Ghost says they may have something proving innocence. They might. I'd be anxious to see that. Yeah, her using caps is just... Somebody just said, is it common to use all caps? No. But I guess she wants that to stand out for whatever reason. This is dated the 11th because that's when they signed these papers. It just hit the... It could be what? Could it be hacked by someone and not real? Kim, really? Seriously? Oh, gosh. Deborah Barlow says, does Idaho have bail that allows them to get out? No. I just explained the only reason why they would allow him out is if at the preliminary hearing the judge in the preliminary hearing feels that maybe there's something there that could be a little off, and there could be a possibility that he could prove that he didn't do it, she would let him out on bail. He'd still be facing the charges, but he'd be out on bail. The judge could absolutely, at the preliminary hearing, say, look, you guys got nothing. Everything you got isn't convincing me, and dismiss all his charges. Could go a lot of different ways here, you guys, at the preliminary hearing. Whitney, he won't have access to a computer. He's being held in a detention center, a jail, not a prison. If Don Schwaga says, we're going to get on to the next document. The next document just has the dates. I can show you it right now. These are the dates for his preliminary hearing that were scheduled by his attorney, which now she's saying, I'm demanding that my client has a speedy preliminary hearing under the rules of 5-1, when she's already had these dates set, and she requested these dates. The defense requested it be put out to June. And now in her motion here, she is demanding or requesting, in other words, demanding that a preliminary hearing be scheduled in accordance with the time limits set forth in Idaho Criminal Rule 5-1, which is 14 days from his first appearance. Okay, so Don says, well, if this does become a death penalty case, would public defender have experience in that type? I don't, she's a public defender. I don't believe that she's death penalty qualified. So they would have to bring in another lawyer that is death case penalty qualified, just like they've had to do in the Valo Dayball case. Ghost says, thank you for answering my question. I was just curious. Happy retirement, by the way. Thank you, Ghost. It's not really retirement because I'm still, jumping on, doing this, covering these. Not only do I do reads, like when I do my reads, you guys, I follow right through the court process, everything. So you get it from me right from my reads right through to the end. Kate Bell, I don't know. This was just filed, a notice of appearance for timely preliminary hearing. So I do believe that there will be a court date set. Let me just check and see in the case file and see if a date has been set for another hearing. Let me just check. There's been no date set for a hearing on this matter with what she just filed. So this was filed on the 12th, you guys, but it didn't hit the court record that we can see until this morning. Okay, well, let me look that up. Shannon Copper says, I thought she was death penalty certified. Let's look that up. Let's look that up. Okay, so yes, she is. Taylor is a board member of the Idaho Criminal Defense Lawyers Association and is certified for the Idaho death penalty. Speaking when she took over as senior public defender, she said it is a necessary job. It is important to make sure that constitutional rights apply to everyone. So she is, from what I'm seeing here, she is death penalty qualified. But I would assume if they end up going for, which I do believe that they are going to go for the death penalty, because there's four lives he took. I do believe that they are going to go for the death penalty. And when they do so, I do believe that she will be bringing on other lawyers, even though she is death penalty qualified. There's no way that she could do this by herself. excuse me, by herself. Shivani says Ann Taylor is qualified to defend death penalty case, according to what I've read. Yeah, I just looked it up too. So, his last appearance was Shivani. When did he appear? Was it the 12th? It would be odd that this is filed. If this was filed on the day. Okay, let me look up his record again here. Notice a hearing right here. Hang on. Oops. Wrong one. Here. No, he appeared on the 5th. So there it is up on screen. He appeared on the 5th. Here it is right here. His initial appearance, felony magistrate court. He appeared on the 5th. And this was filed. Whoops. This was filed. I don't need this one. It's a duplicate. This was filed on the 12th. So just after he appeared on the 5th. Here's the notice right here. His first initial appearance was on the 5th of January. And then on the 12th, she filed this. Wanting a timely preliminary hearing according to with the time limit set out in Idaho Criminal Rule 5.1, which is 14 days. So I had to go back and find that to see when it was he was in court for the initial appearance, and it was on the 5th. His last, no, he never had any bail, Amanda. That's why I said that this whole thing is just a mess. $501 at Super Trooper says that any chance she's trying to resign because her client is a pain in the you-know-what. I don't see any of them wanting to take this case, especially like for a public defender. I know here in Canada, if you're a lawyer here in Canada, I know at least here in Ontario, you have to give so many hours a month to the courts to act as a public defender. A lot of the lawyers do not like taking on cases where the court appoints them the public defender if somebody is indigent, because you don't get the same rate of pay as you would if somebody's hired you. It's a big cut. It's a big cut in pay. So a lot of them don't like doing it. A lot of the ones that are just starting out, and it seems like she's a senior public defender now, so I think she's been around for a while. A lot of the newer ones jump on the chance to become a public defender because it gets them into cases, gets their name out there, gets them known. But I don't see, especially somebody of her stature, she's been around a long time. enjoying taking these cases because it is a big pay cut. And I mean, I'm going to be honest with you guys. The lawyers don't put the same, they do exactly what they have to do and nothing more. When you are appointed a public defender, when you're paying a lawyer, that lawyer is going to go above and beyond anything. They're going to go into every little cubby hole and see what they can pull because they're getting top pay to do that. Whereas when you're a public defender, you're going to do exactly what you need to do to defend, nothing more. You know what I mean? It's sad to say, being that I worked in that field for so long, but so that's why I ended up going out on my own, because I believe you do the same whether the person can pay you $1 million or the person can pay you, you know, 50,000. Everybody deserves the same treatment. But when you're getting paid the big bucks, if your client looks at you and says, hey, here's a stack of, I don't know, papers that I found all over my house, and look through them and see if you can find anything in there, I'm going to do it because you're paying me by the hour. Whereas, you know, you got a client that says, here's a stack of papers I found. They're probably not relevant, but I want you to look at them anyway. That lawyer, if you're a public defender, is going to say, no. You look through those papers, and if there's something in there that you feel may be connected to your case, bring it to me. I'm not looking through all them papers. I don't get paid enough for that. You know what I mean? I mean, it's sad to say, but I'm telling you guys the truth. I'm not going to lie to you. I've seen it time and time again. And then you get a lot of public defenders, especially, I've seen it a lot, where they have, you got a lawyer that's got to put in his 6 hours at the court for, you know, people that have been arrested overnight and everything. And you got to, you know, get up and talk to the judge for them as a public defender. I've seen a lot of lawyers take on clients as a public defender and send them up the river, so to speak, with the courts to get a better deal for their paying client. I've seen it happen. So, just saying, she could always write a book in the future for a nice payday. Ghost, I'm not so sure about that. If she is, somebody just said she's in her 60s. She's getting ready to retire. You know, the publicity at this point really isn't on her probably bucket list. Laying somewhere on a beach in Hawaii probably is, you know. We don't know, but all I'm saying is whoever, I think she has an intern, whoever filled this document out, presented this motion, really needs to go back to school or something, or she really needs to, you know, read these over before she files them, or has her assistant file these, because it's messy to me. Taylor's 57. Well, I'm 59, so, and I retired already. But to me, it's just a mess. I don't think Ann Taylor herself wrote, and no prominent lawyer does up their own paperwork, believe me. This is an intern or something that she's dictated what needs to be in there. And it looks to me, like I said it, this is the first time I read through these documents with you guys. A lot of this looks like it's been copy and pasted out of something else, because it just, like, there's too many, like, little errors like this. Notice is further given that the defendant herewith asserts all rights accorded him or her. This should never have been in here. Ever. Ever. No. And that's just little things that I'm saying. That, to me, I think that a lot of this is just cut, copied, and pasted. Yeah. so that's where we're at, you guys. I know a lot of you also follow a lot of the other cases. Jared is back in court today. I think he's in court right now. Lori Vallow was in court yesterday. I covered that. If you guys haven't seen that, go and check it out from yesterday. Their trials are coming up. April 3rd, Lori and Chad's trial is supposed to start. Letitia Stout is coming up. Let me just see here. Letitia Stout's trial starts March 20th. Her pretrial is on March 9th. The pretrial hearings. So we got some stuff coming up, you guys. As it comes out, as I see it filed, I will bring it to you guys. Yeah, either way, it's embarrassing. Deborah, I agree. I'm not sure that it makes her look like Paddington, that she has no control. I just feel like she's at the stage where it's like she hands it off. This is what I need typed up. Type it up. Go file it. You know what I mean? And I think things get overlooked. Because I think if she would have actually seen this and read through it, I don't think she would have okayed it. I wouldn't have. And especially when you are citing rules that don't apply to this case at all. Rule 46 applies to appeals. So, I mean, I think if she would have read through this, I think she put too much trust in either an intern or a secretary or something. Put too much trust in them to put the right and proper rules in here. I don't know. I don't know what happened. We'll have to see when it, I'll keep an eye on the record and see when this is going to come before the judge, and we'll see what happens there. Okay, so yes, very much so rookie mistakes. Okay, so you guys, Paddington says he's calling the shots and she looks bad to the court. It doesn't matter what shots he calls. He can tell her this is what I want to do, but she is fully responsible for how that's presented to the judge. And this presentation and this motion to the judge is just a mess. That's on her. So anyway, with that being said, you guys, I'm going to wrap it up. Again, this will be going private for about 15 minutes while it uploads, while I get my tags and everything in on it and get it all done up. And if anything else comes up, I will pop back up and I will bring it to you. You're very welcome, Miranda. Thank you guys all for being here. I appreciate each and every one of you. Thank you so much. Please stay safe. Have a great day. Bye-bye for now.